Hello students, welcome for the class of MBA semester 3 Human Relations and Legal Framework. Today is our lecture number 14 and the topic of our discussion for our today's session is Important Provisions of Trade Union Act 1926. The primary objective of our today's session is help to understand the important provisions of Trade Union Act 1926. The contents of our today's discussion is dissolution of trade union, amalgamation of trade union, obligation of registered trade union, important provisions of Trade Union Act 1926, penalties under the Trade Union Act 1926, and central trade union organizations in India. So in the last topic we will see the different trade unions, okay, those who are being operating in India. So the first topic of our today's discussion is dissolution of a trade union. Means whatever trade union that has been in existing in that industrial enterprise, okay, that can be resolved, or that can be that should be dissolved using certain rules and regulation, and that trade union once after dissolving that could not be work to regulate the activities, okay, and primarily try to focus on the legitimate rights of their members. So when we are talking about any trade union, that trade union must be the registered trade union, and if in case they want to dissolve their operations, they want to stop their operations, they want to dissolve that particular body, so that registered trade union can be dissolved in accordance with certain rules and regulations of that trade union. So there are some provisions which are being made over here. If any trade union, registered trade union, those who want to dissolve, so they should have to make an application to the registrar of that trade union, okay, that is called as a notice of dissolution signed by any 7 members, and the secretary of the union should be sent to the registrar within 14 days of dissolution. So whichever trade union that those who want to dissolve that particular trade union and stop their operations, so the members of that trade union, okay, wherever they were made an application for registration, that 7 member along with the secretary, they need to sign some particular application and they need to give the notice of that dissolution of that trade union to the registrar of the trade union within 14 days. Once that particular notice has been received by the registrar will take the further decision. On being satisfied, the registrar shall register the notice and the union shall stand dissolved from that date. Means if the registrar found that the dissolution of that particular trade union is appropriate and it has been communicated by that 7 members along with the secretary to the registrar of the trade union, the registrar first registered that notice, okay, in their register, okay, and then they will be allowed to dissolve that particular trade union, okay, from some particular date. So it has been mentioned, okay, in the register of that trade union, and whichever form of registered which has been made available to them, so they will register that particular trade union, and they will also mention that, okay, the trade union has been dissolved. So they will not further regulate any kind of trade union related activities, okay, in their enterprise. The funds of the union shall be divided by the registrar among its members and in the manner prescribed under the rule of the union or as laid down by the government. Now whichever amount of fund that the existing trade union has been collected, while making the dissolution, okay, the registrar of the trade union, they will divide that fund equally among all the members, okay, and whatever form of other rules and regulations which can be prescribed, okay, by that specific government, state government or central government. So in this way, the trade union can be dissolved. Amalgamation of trade union. Now suppose there will be two or three trade unions are being supposed to be there, okay, that more than one trade, whenever there is a more than one trade union exists in any industrial enterprise, that can be merged together, okay, by means of using amalgamation. So any registered trade union may amalgamate with any other union provided that at least 50% of the members of each union record their votes and at least 60% of the votes are recorded in favor of the amalgamation. So while making an amalgamation, okay, between more than one trade union, so any registered trade union can amalgamate with any other trade union. So it is the provision that could be made available under the Trade Union Act 1926. But there is a condition, at least 50% of the members of each union recorded their votes. So minimum 50% vote need to be recorded, okay, with respect to the amalgamation of that trade union, and of which at least minimum 60% of the votes are recorded in favor of amalgamation. So whichever number of votes are being there has been recorded, out of which it has been identified how many number of members, okay, those are in favor of the amalgamation of the trade union, and the minimum criteria that should be required, okay, that should be in favor of amalgamation of the trade union, it should be what, minimum 60%. So once these conditions are being satisfied, that registered trade union can amalgamate with any other trade union, okay, provided whatever kind of conditions has been specified in this act, along with a notice of amalgamation signed by the secretary, and at least 7 members of each amalgamating union should be sent to the registrar, and the amalgamation shall be in operation after the registrar registered the notice. So whenever the amalgamation process, okay, has been implemented, okay, by that registered trade union, they can amalgamate with any of the trade union provided that these conditions need to be satisfied. Once the amalgamation has been done, okay, regarding that a notice of amalgamation has been prepared, okay, and it should be signed by the secretary and as well as minimum 7 members of each amalgamating union. So whichever number of unions that those are being comes into amalgamation process, okay, that notice need to be sent to the registrar of the trade union, and their amalgamations will come from that effect whenever the registrar register that notice from particular date. So in this way the amalgamation of the trade union can be happened. Now these are called as the obligations of registered trade union. There are some minimum prescribed rules and regulations, okay, which can be made mandatory to certain trade unions, specifically the registered trade union. Now what are these obligations? The general fund of the registered trade union should be spent only on the objects specified, such as payment of salaries, allowances, expenses of its office bearers, etc. Means whatever kind of obligations, the first obligation would be here, okay, they primarily need to spend on the salaries of the office bearers, along with whatever form of allowances and other expenses that are being connected with the office bearers. So first of all we need to pay that whatever form of expenses, immediate expenses that are being related with the office bearers, along with its administrative and audit expenses. Whatever form of administrative and audit expenses are being supposed to be there with respect to that registered trade union, that they need to pay to the concerned authorities. In case of any kind of prosecution or defense or any legal proceeding, okay, against that particular trade union, okay, they need to pay whatever form of charges, okay, or charges of even advocates, and whenever they are going to involve in the resolution of dispute related processes with conciliation, arbitration and adjudication processes, okay, they need to pay that minimum charges. Or protecting its rights, conduct of trade dispute, okay, compensation or loss arising of the trade dispute, okay, compensation for loss arising of the trade dispute, provision of educational, social and religious benefit and other allowances on account of death, old age, sickness, accident, unemployment to its members, or publication of labor journal, etc. There are some other related matters which has been connected with the particular registered trade union, okay, whenever they are regulating the various activities. So during the period of dispute, okay, they need to provide some sort of compensation, okay, that has been loss arising due to the trade dispute, particularly to the workers. Compensation of loss arising out of trade dispute, provision of educational facilities, social and religious benefits to its members. So some sort of benefits in the form of free education or adult education, some social security measures, some sort of religious benefits that need to be provided to its members, along with some different forms of allowances, okay, particularly on account of the death of the member of the trade union due to, suppose say, old age, sickness or accidents. So whenever any of the things that can be applicable, okay, they need to arrange either some fundraising activity and distribute the fund among the deprived person, okay, with respect to either old age, sickness or accident. Or during the period of unemployment to its members, okay, say for example during the period of lockout or retrenchment also, they need to provide the compensation to its members. If they want to publicize certain labor journal, okay, or some publication which are being related with, suppose say, newsletter, so even they should have to meet these expenses, and they can conduct the several activities with respect to that trade union to publicize their events time to time in this trade journal. The trade union may set up a separate political fund for the furtherance of civic or political interest of its members. So we have been identified that there are many political agendas that are being connected with the trade unions. So they are running the different activities, and particularly whenever they are organizing the some form of, suppose say, dispute, okay, or suppose there is an industrial unrest among the members, okay, so sometimes they are arranging gheravs, strikes and so many things are being there. So they are using some sort of some separate political fund, and there will be a fundraising activity from its members. Contribution this fund is not compulsory, so it is to be taken into account, okay, however number of workers are being available, okay, those who are the members of that trade union, they time to time collect some fees, okay, as a part of fundraising activity, and they will whenever they will require that particular fund, so they try to make the use of political fund, okay, particularly to protect the interest of their members. Even some during emergencies, that fundraising can be very useful to their members, okay, particularly during the period of sickness, accidents, okay, or unemployment situation, or during the period of lockout or strike, that fund can be utilized. There are certain other obligations, okay, the account book and the membership register of the union should be kept open for inspection by any of its office bearers. So it is quite necessary that whatever form of registered trade union, okay, there is an important obligation with respect to preparation of certain account books and some minimum registered membership register, okay, of the trade union, which should be kept always open, okay, for inspection, okay, by its office bearers. So office bearers could be made available that particular account book and membership registered, okay, during the inspection by the registrar of the trade union. A copy of every alteration made in the rules of the trade union should be sent to the registrar within 15 days of making the alteration. Whenever there is a change in the regulations with respect to working in the trade union, okay, or whatever the service condition which has been specified, and suppose that service condition has been changed, just after the change, okay, the registered trade union need to inform to the registrar of the trade union within 15 days, okay, after making the alteration of with respect to whatever rules and regulation of the trade union. Also, there are some mandatory rules and regulations which are being made available to the registered trade union, okay, and annual statements of receipts and expenditure, okay. So whatever number of receipts, okay, by means of which they were collected the funds, okay, and along with their expenditures statement, that need to be prepared, okay, and need to be submitted time to time. Also some assets and liabilities, whichever number of assets and liabilities which are being available to the union or they were purchased, okay, in the last financial year, they need to submit all these details, okay, at the year end on 31st December every year, prepared in the prescribed form, and duly audited report should be sent to the registrar, okay, from time to time. This statement should be accompanied by the statement showing the changes in the office bearers during the year, and copy of the rules are amended up to date. So along with that, some particular form of statement which are being related with the statement of the office bearers. If the office bearers has been changed, okay, over a period of time, okay, suppose the secretary has been changed in the last 6 months, so the copy of appointment of that particular office bearer means secretary need to be attached over there, or whatever form of rules has been amended, okay, from that particular date. So it should be up to date report that is need to be sent to the registrar of the trade union. So these are the minimum obligations that could be made available to the registered trade union. Now there are some important provisions which are being made compulsorily for any of the trade unions in India. We will already discuss some of the provisions that, okay, any 7 members can form a trade union, okay. So this is a very essential criteria to make any kind of compliance with respect to registration of the trade union. So the minimum 7 members are very much necessary to form the trade union. So there should be also at least 10% or 100 of the workmen whichever is less or engaged in the employed in that establishment or industry with which it is concerned. So minimum 10% of employees must be on the roll of that particular trade union, okay, or there will be a criteria of minimum 100 workmen should be engaged or employed in that particular establishment. It has on the date of making an application not less than 7% of its members who are workmen employed or employed in that establishment or industry with which is concerned. So it is quite necessary, okay, on that particular period of time whenever the process of registration can be made to the registrar of the trade union, there must be, okay, there must not be, okay, less than 7 persons those who are employed in that particular factory or industrial establishment. If it is less than 7, okay, the one cannot make the registration of that particular trade union. As well as some particular information that is related with the registration of the trade union that is need to be mentioned: name, occupation and address of the member as well member's place of work. So where does that particular office bearers, okay, that are being relating with that particular trade union, their every information, okay, along with the address of the head office, name, age and address and occupation of the office bearers, okay. So all these information could be made available to the registrar of the trade union according to section 5 of the Trade Union Act 1926. There are some other provisions which are being made, okay, say for example minimum requirements for the membership of the trade union. Okay, minimum requirement would be what, it should not be less than 10%, or 100 minimum workmen must be there in that particular factory, whichever is less to the subject to the minimum of 7 engaged or employed in that particular establishment. Either 10% or it should be minimum of suppose say 7 members must be there, okay, while making the registration or suppose say one can obtain the membership of trade union. So if suppose I want to join any particular trade union, so I should have to look over there, okay, how many number of members are being there. So there would be minimum 7 members would be there in that particular trade union, or out of 100 workers, okay, there would be, suppose say 10% should be the members of that particular trade union. So I will decide whether to join that organization or not. This has been mentioned in section 9A. Cancellation of the registration of the trade union. If the certificate has been obtained by fraud or mistake, okay, in that case, okay, there will be a possibility that registered of the trade union can cancel his particular registration certificate. This has been mentioned in section 10. Some criminal conspiracy in case of trade dispute. If it has been identified that any of the office bearer, okay, those who are being involved in the conspiracy or fraud, okay, are doing some unfair labor practices. So according to section 2, okay, there will be the case will be registered according to Indian Penal Code, okay, and there will be a necessary action will be taken against that particular trade union or the office bearer of that trade union. Okay, so this has been also mentioned in section 17 of the the Trade Union Act 1926. Along with that, they need to specify the returns time to time. So before 31st December, they should have to submit the various forms of details to the registrar of the trade union. Okay, that may cover, okay, a general statement along with some audited reports, okay, with respect to income statement or profit and loss accounts, okay, along with some other forms of receipt and expenditure, or say for example, whatever form of assets and liabilities are available to them. So this has been made compulsory according to the section 28, okay, and will be applicable to every registered trade union. Disqualification of the office bearers, okay, which particular person can be appointed as an office bearer in that particular trade union. He must have a minimum of 18 years, and also that particular person could not be appointed as an office bearer, okay, subject to the condition, okay, the convictions of the offense involving the moral turpitude, okay, and not applicable when 5 years have been elapsed. If any person those are being with those are being uh, there is some particular legal proceeding that is going against them, okay, and that particular person could not be appointed as an office bearers. If the particular person those has been went recently with certain kind of legal proceedings and has a jail of, suppose say 5 years, okay, so within 5 years that particular person could not be get appointed over there, okay, and according to section 21A, these provisions has been made compulsory to that particular trade union. Now there are various penalties are being available according to the section 31 and 32 of the Trade Union Act 1926. So for example, okay, for making the false entry or in any omission in the general statement required for sending the return. If any of the trade union, those who are making a return, okay, before the 31st December, okay, and they have made any false entry with respect to that any form of statement, either income statement, profit and loss account statement, or any other assets and liability related statement, so there will be a fine, okay, up to rupees 500 on continuing the default. Additional part rupees 5 for each week, not exceeding rupees 50, can be imposed, okay, on that office bearer as well as on the trade union. For making any false entry in the form, okay, so there are several types of forms which are being available, particularly during the process of registration. Even dissolution, amalgamation would be there, okay, or some sort of membership, okay, related, okay, so there will be a fine of rupees 500. According to section 32, okay, supplying false information regarding the trade union. If any of the trade union, those who are submitting any kind of false information to the registrar of the trade union, there is a fine of rupees 200 that should be imposed on the trade union. So these are the penalties, primary penalties, which are being available under the Trade Union Act 1926. Now these are called as certain kind of trade union organizations in India, okay. These are the big trade unions which are available in India. Let us have some overlook with respect to the name. The first one is called as All India Trade Union Congress, AITUC. Okay, All India Trade Union Congress. Another one is called as Bharatiya Mazdoor Sangh, okay, BMS. The next one is Center for Indian Trade Union, okay, this is called as C2. Hind Mazdoor Kisan Panchayat, HMKP, okay, Hind Mazdoor Sabha, HMS, Indian Federation of Trade Unions, IF2, okay, Indian National Trade Union Congress, INTUC, okay, National Front of Trade Union, okay, NIFI2, National Labour Organization means NLO, the Trade Union Coordination Center, TUCC, and National Mazdoor Union, NMU. So these are the large trade unions, okay, those are available in India. These particularly those who are being taking the interest of his member and protecting the legitimate rights of his member. So these trade unions primarily they are working across the nation, okay, within India, and try to protect the their members. So that's all about our today's session. Thank you very much.